to have or to be from or to have basically of or from livery. The livery of something is to get it. And so one would sue out their livery of their estate. And this used to be a rite of passage that all wards, infants, if you will, had to do eventually in order for them to prove that they could handle their own affairs by basically forcing them to open their own court and go through their own procedure and sue their guardian. There was no malice intent behind it. It was just a process that they had. After a while, the Court of Wardens and Liveries ran from about, and don't quote me on this exactly, I think it ran from like the early 1500s or maybe mid 1500s to around 1660, right around when they burned London to the ground, when the Khazarian mob burned London to the ground and then initiated the Sesquiquivai Act. They shifted, they hid what they were doing, and what they did was they pretended to get rid of the Court of Wards and Liveries, but they just restarted it with a different name, and they called it the Court of Wards. And what they did was they allowed the East India Trading Company to run it, which I thought, well, doesn't that make perfect sense? Now you have a multinational corporation in charge of running the administration of the estates of people who are considered to be lost, abandoned, or dead, like as in under the Sesquiquivai Act. This system of administering people's estates by corporations has been going on for a very long time, much, much longer than people even begin to realize. It's hundreds and hundreds and hundreds of years ago. When you know that and you can see the long, colossal fight between Roman civil law and English common law, that it stares you in the face. It's just something that becomes so blatantly obvious. It's like a light bulb goes off. You're like, oh, okay, yeah, of course that's what they're doing. Because they were doing it back then too. They just changed the name of this and they changed the name of that. And, the East India Trading Company and the United Company of Merchants just turned out to be, basically the United States Federal Corporation afterwards, and yada, yada, yada. And you can see all the connections. But in creating that last status doc, I want the convened jury to render a general verdict. Okay, so now I'll get into reading these verdicts, and I am going to read most of this because it's not all that long. It's only 2 pages. So again, this is from Bouvier's, so 1856 edition. Verdict. Practice. The unanimous decision made by a jury and reported to the court on matters lawfully submitted to them in the course of the trial of a cause. Verdicts are of several kinds, namely privy and public, general, partial, and special. Privy basically means private. So you got private and public, then you've got general, partial, and special. A privy verdict is one delivered privily or privately to a judge out of court. A verdict of this kind is delivered to the judge after the jury have agreed for the convenience of the jury, who after having given it separate. This verdict is of no force whatsoever, and this practice being exceedingly liable to abuse is seldom, if ever, allowed in the United States. Now here's the thing. When we're doing the process, I thought about this for a second. I was like, oh God, is that what we're doing with the process? And the answer is no, because I realized that the jury gives the verdict directly to the judicial coroner in the presence of the sovereign who is doing the proof of life and proof of age inquest. So it's not given privately. Now, if they were to ever argue, well, you didn't go through our court, well, I don't have to. I can convene a court of record wherever the hell I want to. If it's in the middle of the woods, it doesn't matter. It doesn't have to be in your court building. And the other thing is, too, is we take care of this by then filing the verdict onto the public record and making it public anyway. They couldn't win this argument both directions, but a public verdict is one delivered in open court. Now, that's technically what you're doing. When you're doing your proof of life and proof of age inquest with the 12-member petite jury, you're in your court. Your court is open and in session. And you guys can be as formal or informal with that as you want to. Perhaps simply stating it, or perhaps the judicial coroner stating it, saying, the court of record of the House of Doe is now open in a session, and this is in regards to a matter of a proof of life and proof of age inquest. Something like that. That's basically all you would have to say if you even wanted to be that formal about it. But the fact that everything that they write down or that is written down in the status docs takes care of it anyway. So a public verdict, this verdict has its full effect, and unless set aside, is conclusive on the facts. And when judgment is rendered upon it, bars all future controversy in personal actions. A private verdict must afterwards be given publicly in order to give it any effect. And again, this is why I say this is why we file the proof of life, proof of age inquest onto the public record as a judgment. But as I said, it's not considered a private or privy judgment when we do it the way we do it anyway. It's the whole court and everybody's there. And here's the thing. Because a proof of life and proof of age inquest is a matter of life and limb, under the Magna Carta, it specifically states that matters of life and limb must be considered gratis and shall not be denied. Okay, if it's my life and limb, I'm the sovereign. There is no defendant, because you are the one suing out your own estate, that there is no legitimate guardian. Okay, the state is only administering the property of the abandoned estate because, well, they're basically warehousing it because it's been abandoned. So you're just coming and just wiping the slate clean, saying, nope, I'm here. There is no defendant to sue because there is no one. None of them are ever going to put up their hands and be like, oh yeah, I'm your guardian. They just won't do it. So there's no point to try to go running around and trying to serve a bunch of people saying, yeah, show up for this. Not only would they not show up anyway, they just lie and say, we don't know what you're talking about. So there's no point. We just do it, get it done, put it on the public record properly, rebut the presumptions, and it's over. Here's the fun thing. A general verdict is one by which the jury pronounce at the same time. So the term pronounce, so when you're pronouncing, that's what you do, is you pronounce a verdict. So the jury pronounce at the same time on the fact and the law, either in favor of the plaintiff or defendant. And again, there is no defendant here. It's just basically the petitioner, even though we just state it as we're just one of the people doing this before to do a proof of life and proof of age inquest before this petit jury for all of the reasons that are stated in the status docs, which I'm not going to get into. But those of you who already have them done, you know what they say. The jury may find such a verdict whenever they think fit to do so. This is why we do not need a judge in an inferior court to render what we do lawful. That's where you get your power from. What I did was I used this term, general verdict, to put into the final status doc as far as the delivery of the entire estate. And then I also put together a more specific final court order in the proof of life and proof of age inquest, saying that the judicial coroner, now speaking for the court, the tribunal of which was the 12-member petit jury, and the 12-member petit jury has now pronounced a general verdict, which the court now states as final judgment. It was something like that. I mean, I'm kind of paraphrasing it, but because I just wrote it up a couple days ago and then I perfected it out. Now the process is properly through this understanding of what a general verdict is, which is why I wanted to make sure that everybody understood it here. And partial verdict is an aspect of criminal case. Don't need to get into that. Special verdict is, and this is interesting because this is what they're doing in the inferior courts. A special verdict is one by which the facts of the case are put on record and the law is submitted to the judges. Well, that's what happens in every single inferior court case. So this is what they're doing. And here's the thing. I was looking through a appellate court case in Colorado. I was working on an appellate for somebody else in Colorado. And this case that I was kind of looking at to just understand how to make the brief and get the arguments in and whatnot. This case was about a guy, or I guess a group of men, who were basically kind of in front of a courthouse handing out flyers to everyone who was coming into the courthouse, asking if they were there to be a potential juror, handing out these flyers and teaching them that, they don't have to follow the court's orders and all these various different things. And aside from the fact, I think I understand why the state brought charges against them, not just because of the fact that they're greedy and they're all filthy Luciferian bastards. It was making it sound like the verbiage that these people used could have been put much better. Basically, all they would have had to say in these flyers was a proper description of the difference between a general verdict and a special verdict. Honestly, that would be it. I mean, if I was going to give out a flyer, I'd give everyone the definition directly out of Bouvier's and be like, look, you have the right to do this whenever you think fit to do so. And down here is what they're going to try and do to you, and say that you're only given a special verdict because the judge will say that you get to try the facts and he gets to try the law. Well, it's not what this says. So anyway, just as a side note, when we do things properly, there's nothing they can do. Okay, this is why I said before that there is no substitute. There's no silver bullet. There's no quick fix. You have to learn these things, and they're all in my head because I've been doing this 25 years, but I'm giving everyone the absolute essentials with some meat on them. I'm not saying I'm just giving everybody bare bones stuff here, but the absolute essentials with enough of the meat on them so that you're lean, you're strong, you know what's going on, you can say these things, understand them, and implement them as you need to, so that you have confidence. Because if someone doesn't have confidence in what they're doing, then they're not going to do it very well. That's for sure. And the other thing is that nobody has more interest in your case than you do. Even if you were to pay me, I can do as best as I can in it. But again, I'm not going to care about it as much as you do or should. And so therefore, it's always better for people to write their own suits because they're going to be more passionate about it. And of course, yes, it's fine to have someone edit it, or someone to look over it like me. That's fine. That's one thing. But only people are going to be interested in what their own situation is. And you can't really pay anybody to be interested in anybody else's situation. I know that sounds slightly heartless, but it's just the truth of the matter. But that's why we're going over all this stuff. And that's why you guys are in class. So a special verdict, put the facts to them and the law submitted to the judges. The jury have an option, instead of finding the negative or affirmative of the issue as in a general verdict, to find all the facts of the case as disclosed by the evidence before them, and after so setting them forth, to conclude to the following effect, quote, that they are ignorant in point of law on which side they ought upon those facts to find the issue. And if upon the whole matter the court shall be of opinion that the issue is proved for the plaintiff, they find for the plaintiff accordingly, and assess the damages at such a sum, etc. But if the court are of an opposite opinion, then they find vice versa, meaning for the defendant, close quote. Okay? So again, in my little purple note here, we the people are not ignorant on any points of law that we bring forth. That would be dual-mindedness and it would show that you're an infant. We're not ignorant. Honestly, there can never be a special verdict in a court of record because that would suggest that the sovereign, one, doesn't understand his own law that he's decreed, which would make him insane, and two, that the jury doesn't have the right to determine both the facts and the law. When clearly the sovereign's saying, look, and here's the thing, when the sovereign clearly says to the jury, this is what the law says, I've decreed the law, this is the law that you follow, nothing else, there is no statutes, acts, ordinances, and codes. If I haven't decreed it to be a law of the case, it's not part of the law of the case. That's it. This is all you're dealing with. You don't have to worry about the 10,000 pages over there that the state says you're supposed to be looking at. Forget it. It has no place here. So, anyway, I'm not going to read the rest of the this, but this is the point, that you get that this is what they're doing in their inferior courts. I guess I will read this last sentence because it's kind of interesting because this is what they're talking about. In their system is basically what's now become what we consider to be an appeal. The special verdict, when its form is thus settled, is, together with the whole proceeding on the trial, then entered on the record. And the questions of law arising on the facts found is argued before the court in bank. Now, in bank means before the entire court. And so if you've got more than one judge, like in an appellate court, it means all the judges in the court. So court en banc means the entire court. And decided by that court as in a case of demur. And so what is a demur? A demur is when someone answers a suit that has been brought against them and they say, I agree to all the facts. but the law doesn't apply to me. That's what a demur is. Understand that. And then if either party be dissatisfied with their decision, he may afterwards resort to a court of error. So what's a court of error? Okay, so court of error is where you bring a writ of error. It's basically where you challenge the judgment of a court of record, but only if there was a matter of law that was ruled upon incorrectly. The facts are always done, put away, solid, never to be tried again, as it clearly said in the definition of a court of record that I read when we were going over courts. But if a matter of law has been screwed up, messed up, whatever, in that hearing or in the procedure, then you can do what's called a writ of error. And a writ of error is where you literally, it's kind of like its own new, well, every writ is its own new action. And that's the way you want to think about it too. You say, okay, look, yeah, this court of record did such and such, but they erred here, there, wherever, because it didn't follow the law. And in a court of record, it would be because it didn't follow the common law. Now, is an opposing attorney or these stupid inferior judges ever going to even know how to file a writ of error? The answer is no. They'll file an appeal. Well, number 8, there is another method of finding a special verdict. This is when the jury find a verdict generally for the plaintiff, but subject, nevertheless, to the opinion of the judges or the court above on a special case stated by the counsel on both sides with regard to a matter of law. This is what people know now, the inferior court system, as an appeal. That gives you structural, historical background as to where these things come from, just simply by reading the definition of verdict, which I absolutely found fascinating, particularly the thing about the general verdict part. So that's verdict. And, okay, now, how to file in a court of record for default judgment. This is where we get into the fun stuff. We're going to pull up Drew's case, and we're going to keep going back and forth with Drew's case about how this happened. Okay, this is a court of record action. This was, notice the names here. Corey Jackson. Corey Jackson's a judge. I think this was a district attorney. I think this was a cop. So this is what a court of record suit looks like. So it's claim and action of trespass. You can leave the claim off if you want to. You can just say action of trespass, but I'd like to put the word claim in there. So claim and action of trespass, verified, attested, sealed. What does this mean? It means it's verified at the end, meaning that everything that he says, this man says herein, is true and correct, and verifies the same to be so. It is attested, or it's sometimes the AT on this side is removed and the D is removed, and it's just teste, which is what it used to be called. And at the bottom of every single court case, I always make sure that there's a teste. So teste mipso, which basically means, in Latin, that would be basically that he swears to all, or he's kind of more like he swears to himself. So it's bringing his own testimony or his own attestation that this is true and correct, and what the finality of the court is. So, Brett Andrew, House of Nelson, sovereign of the court, holder of the seal of this court, with said seal thereof hereunto affixed, attested by his own hand, that's again the teste attested by his own hand, who stands upon the land, Republic of, this should actually say Colorado, not Iowa, but this was probably a middle draft, so it's just some things are incorrect, because I'm sure Drew took this from a draft that I had, so it should say Colorado. Republic of Colorado, this 10th day of November in the year 2018, and then you put your seal on there. And Drew's got a really simple seal. I mean, not to say that it's wrong, it's perfectly fine, but this just shows you how simple a seal can be. His is just a wolf print. Okay, so that's the test day. Just wanted to state that really quick. So back up here. Okay, and obviously it's sealed, which I just showed you. So this is what it is. So court case number, and this is where you'd put make sure that when you go to the court clerk, make sure that you ask them for an at-law case number. Say, look, this is a case at law. It needs to have an at-law case number. I do not want a civil case number. Make sure that you give it an at-law case number. And they pretty much have to, because clearly you're either at law or you're in equity, as the definition said before. My apologies. Not the definition, what it said out of the 1818 Illinois Constitution. So you got courts at law, and you got courts of equity. So I don't want a civil suit. I don't want an equity case. What I need is an at-law case number. And again, this gets back to exactly what I said you should do when it comes to like how you handle the county recorder, the same way. You can go to the clerk of the court and ask for the same kind of printout that you asked from the county recorder. Say, hey, what are all your different classifications of cases? You know, all the little numbers that you, all the little letters and whatever that you put in the case number. Great. I want to see the printout of what each of those various different groups of letters stands for. Get that first, and then you can go back and then say, I need this filed under such and such category in the clerk's office. That way, there's no ambiguity. They're not arguing the fact that, oh, I can't do that. Well, yes, it says right here you can. And this is one of your categories, so file it here. And it just saves a lot of headache. I would take a witness with you as well every time that you go to file something into your court of record, because then what you're doing is you're making sure that someone else could write out an affidavit and say, hey, yep, on such and such a date, he filed such and such, and I heard him demand that it be filed into an at-law case number, or whatever the situation is. I heard him demand the clerk to file on demand or something, whatever the case was. You take a witness, then you can take a tape recorder, and it doesn't matter if you show them the tape recorder or not. You can just take the tape recorder, and then the witness can write out the affidavit of what happened based upon what you guys recorded off the tape recorder. Works perfectly fine, and no one's going to know anyway. Use every advantage you possibly can against these assholes. That's getting your case number. So you file the whole thing. This thing's 14 pages, and I'll go through some of it. I'm just going to go through the main sections, because again, I cover this ad nauseum in the ins and outs of court class. Yes, your wife can definitely be a witness of your action or your affidavit as to what she saw, witnessed that day. Yes, of course. What are we doing here? We're doing action of trespass. So you do your declaration. So it's an action of trespass. This is the entire declaration. And then this specific section, section number 1, is the venue. So this is where you describe where this stuff happened. So all events described herein and all matters relating thereto occurred on unincorporated land in the county named or known as Gunnison, in the republic named or known as the state of Colorado. And therefore, all actions herein shall proceed by necessity, and I threw that in there to really get rid of the civil law part, because there is an important part of the aspect of necessity. You see, what Roosevelt did in 33 to steal everything, he said, and this was in the bills, he said, oh, by necessity, this is necessary. Well, there's a maxim of law that states that necessity knows no law. Was he certainly stretching that idea when they did what they did in 33? Yeah, obviously. Well, guess what? I can do it too. That's why I underlined it. And therefore all actions herein shall proceed by necessity, according to the course of the common law, in a court of record in the state of Colorado. I should say the republic was already stated here, but this could be worded slightly different. In the course of the common law, in a court of record on the land of the republic named Colorado. That would probably be a better way to say that. You come back and you read something and you're fixing something every time. But anyway. Okay, so see the law of the case. Section, the court, the rules of this court are as follows, which are included by references if fully stated herein. So then you just basically included all of the rules of the court as in the venue part. So law of the case, this decrees the law of the case. It says the law of this case is hereby decreed, : the law of this case, attachment A, is incorporated by reference as though fully stated herein and applies to all causes of action and all declarations at law in this court of record at all times. At no point or time shall these actions in this court of record be subject to the following for any reason: principles of equity, maritime amity, ecclesiastical or military jurisdiction, practice, rules, appeals, or decisions, save what the lawful tribunal of this court of record shall deem appropriate, as is stated in the law of the case. I should say, as this lawful tribunal of this court of record shall order appropriate would probably be a better way to put that, not deem, but order. Because deem is not technically the proper word to use there. I mean, it's okay as far as description is concerned. But here's the thing. All language that you write out in your suit at law is exactly how you understand it. Okay, it's not subject to how the judge understands it or the attorneys because they don't understand anything. It's only up to how you understand it. So if you say, yeah, this is what I meant by that, or this is what this means, or that's what the definition of this is, then that's it. That's what it means. If the judge, has any questions, have him ask you about what the law is. Don't understand the law, judge? Ask me. I'll tell you what the law is. So commencement for all actions comes now. Brent Andrew, Alton Nelson, who is at all times mentioned in the following declarations and action at law, one of the people of Colorado, an American citizen, having come of full age, having been found to be living, competent to give testimony stated herein. Now, he could state all these things because he'd already done his doc set at this point. Hereinafter plaintiff, and in this court of record, hereinafter superior court, comes upon an action of trespass in the case against Corey Jackson, a man, Skip Spear, a man, and Betsy Nisbet, a woman, who I think might have been a court clerk. Or it was either court clerk or district attorney, I can't remember. Anyway, it says what they are down here. Hereinafter defendants, based off an action to deprive plaintiff of his rights to hold a court of record and calls them to answer plaintiff in these said actions in the superior court of record to wit. Court fees, I just basically wipe out the court fees. I just say, look, you can't charge me a fee for filing my own suit, so go fuck yourself. The statement of the cause for action of trespass and trespass in the case. And this is where you actually get into the meat of what it is. This is an action and claim of trespass and trespass in the case in a court of record under common law to redress the deprivation of a custom or usage, unalienable right, privilege, and immunity secured to plaintiff by the 1st, 4th, 6th, 7th, 9th, and 10th articles of the Bill of Rights as amendments to the Constitution of the United States of America, known as said Constitution's Bill of Rights, the Expatriation Act, and all other rights and immunities that a people of the several United Republics of America possess under the common law, all of which the plaintiff is and was protected by at all times mentioned in all cases, in all causes of action stated herein, and furthermore, the jurisdiction of this court is invoked upon the same. You said where the jurisdiction of the court is invoked, which is basically all the common law aspects of these protected said rights under the foundational documents. Plaintiff seeks an order, judgment, and execution from the superior court, finding and declaring that the defendant, who was within the inferior court, have exceeded her jurisdiction regarding plaintiff's substantive rights, and seeks a judgment from the superior court for the damages stated herein as a result of the injuries caused by the defendant for the harm they have caused the plaintiff in excess of said jurisdiction. See attachment A, law of the case, for all of the law referenced herein. The same is incorporated by reference as if fully stated herein. And then statements of facts. So this is where you state all your facts. I'm not going to go through Drew's whole case. Basically what happened was that he defaulted him on this cause of action, which proved that the inferior court didn't have jurisdiction. And then what he did is he took it to binding arbitration. So statement of facts. Plaintiff now states the following facts regarding of events happened November 10 in the year 2018 and after, and declares the same in these causes of action to the best of his knowledge and recollection to wit. Colon. At all times mentioned herein, plaintiff is and was one of the people of Colorado and an American citizen. I would actually separate that because technically you're only supposed to say one fact per paragraph. What you should do is put a period here and then copy and paste this whole part, and then at all times mentioned herein, plaintiff is and was an American citizen, period. That should be like number 8. So if I redid this again, you should have only one fact per line. At all times mentioned herein, plaintiff is and was domiciled on private land, County of Gunnison or County of Alamosa, Republic of Colorado. At all times mentioned herein, plaintiff has been found to be living and has come of full age. Right. At all times mentioned herein, plaintiff was and is a free man. At all times mentioned herein, plaintiff was and is the donor, grantor, settlor, sole lawful executor, and sole lawful heir of both the Brett Andrew Nelson legal estate and the Brett A. Nelson trust. That's where you put in the facts that coincide with everything that you do with the doc set. Right? And that's all you need to say about the doc set. It's just basically a line like that. That's it. I mean, you could add some other things in there if you want to, but you're basically saying, look, I'm the sole lawful heir of this estate that you're attempting to administer. The defendants have been appointed as trustee of Brett Andrew Nelson and Brett A. Nelson. Again, that's an aspect of the KW. Plaintiff did not sign the birth certificate contract of Bryce Andrew Nelson on or after December 4th, 2014, and has therefore never relinquished nor waived nor abandoned any rights over said infant child. Because how this all started was a custody battle thing where his ex took his son to the hospital over basically a cold or some dumb shit, and he was not under any circumstances going to allow his son to be poked with a needle, which of course is his right because his son is his property, which of course he claimed in the status docs. That's part of what we do in the status docs is we claim the children back. And his son at this time, I think, was 4 or 5, something like that. Clearly had not yet come of full age, so he was still the property of Drew. And then he went to the hospital, basically took his son out of the hospital and said, no, you're not doing this. And basically then proceeded to leave. And the frickin' stupid ass Nazi nurse literally came all the way out into the parking lot and like jumped on the hood of the car. And he was like, you know, you can get off my car and I'm going to move now. She's like, I'm not moving. You're not taking that boy. I'm like, well, tough shit. It's my property. Get the hell off. And proceeded to then slowly drive away, hoping that the idiot would jump off, which she never did. And then the cops got called, and that's how that whole thing started. That's how this whole case precipitated. The backstory, basically. So, plaintiff has claimed all rights and authorities over Bryce Andrew Nelson and his estate on the public record and on the record of 2 superior courts of record where no return was presented in opposition to this claim. So he had done 2 other suits at law like this. So he's stating that they didn't answer either one of them. Plaintiff filed an action into the court of record cases, all these different cases, with special term in Gunnison County Courthouse to basically squash all this bullshit. The records of these actions show that these actions at law were filed into a superior court of record. The filings were appropriate for an action at law. The filings were into a court of record. The body of these counteractions and the decreed law of the cases placed the filings into common law. Defendants in these cases were duly served by Gunnison County Sheriff's Department. A lawful summons was contained in said service inside the body of the actions as appropriate for an action at law. The record reveals in all cases that no lawful returns had been made by any defendants at any time. The records of all cases reveal that no defendants requested a jury. In a court of record, the tribunal is separate from, it should say separate from the magistrate, but separate from the judiciary. That's not, again, a critical error. That's technically correct. Colorado statute recognizes common law. Corey Jackson was made aware of this repeatedly. That's the judge. Throughout the proceeding of all cases, Corey Jackson continuously stepped outside his role as a magistrate with no authority to do so and attempting to assume the powers of the tribunal of the court of record without leave of court, meaning without Drew's permission. Each time the magistrate, Corey Jackson, exceeded his jurisdiction, the lawful tribunal of the court corrected his illegal actions with a writ of error, which, as I said, I have the templates for the writs of error, and Drew did plenty of them. Every time that this idiot did something, we corrected it with a writ of error. And here's the thing, as long as you correct the record, I don't give a damn what they do. You're correcting the record properly. They're the ones that are acting outside the law. So, you correct it, you do what's proper, so be it. What you don't do is get into a big tizzy fit and scream to high of heaven, they can't do this, and start acting like an infant. Just correct the record. Be done with it. Like, you didn't have any authority to do that. You're only a magistrate here, you moron. And the magistrate is independent of the tribunal, and I'm the tribunal. Done. Writ of error. Fixed. Each writ of error contained a show cause motion requesting defendants and magistrate to show cause as to if the court had acted beyond the law. That should say, as if they should act beyond the law, because technically the court's above all that. But you get the point. Each writ of error contained law and a description as to why the writ was evoked. Neither the magistrate nor defendants ever answered any of the show cause motions at any time. They never denied the validity of the common law court. The magistrate, instead of answering the show cause, would reply, no action taken, which is what he was doing to reply in his quote-unquote orders, which weren't really orders. He just, because he couldn't. I mean, if you think about it, when the judge puts down no action taken and files it into the court, of course he can't take any action because it's not up to him and he's the one being held in contempt anyway. So of course he can't take any action. It's just funny that, that's all they did because obviously they couldn't take any action if they wanted to. They're not supposed to be taking any action because he's only a magistrate. Neither the magistrate nor defendants challenged the authority of the court of record at any time, although given multiple opportunities to do so in a request to show cause. I should say in requests to show cause, but no big deal. On July 10th, 2018, Corey Jackson was disqualified as magistrate from the Superior Court of Record, as case numbers blah blah, by the lawful tribunal of the court, for his consistent acts in excess of his jurisdiction and blatant incompetence in law. Corey Jackson claims to be a judge in the state of Colorado and is therefore required by the state of Colorado Code of Judicial Conduct to be competent in law. Corey Jackson, after disqualification, continued to trespass in the cases, making orders in excess of the jurisdiction of his previous station as magistrate. On September 27th, Corey Jackson, with no authority, no lawful tie to any of the cases, and in excess of his previous jurisdiction as magistrate, banned the plaintiff from filing in his own court, thusly depriving plaintiff of due process and his birthright to the court of record as protected by the federal constitution. The filing was not from the tribunal of the court. The filing did not contain the seal of the court. The filing was in the equity jurisdiction of the court, a different jurisdiction than the court of record. The filing did not comport with CRCP rules. See, what we're doing here is we're using their rules against them. So we're saying, look, their filing didn't comport with that rule and was an invalid filing with no bearing on the proceeding of the court of record. So court clerk Betsy, whatever, acted on this illegal action and utilized her position with the court to deny plaintiff access to his court. Nibbitz, the clerk, refused to file plaintiff's file-on-demand filings. At all times, plaintiff followed the rules of the court and the laws in which guided the court. All parties involved were furnished with the rules of the court and the laws of the case. The request to ban plaintiff from his court came from Skip Spear. Skip Spear works for the state of Colorado and took an oath to uphold the limitations of the federal constitution. That should say, and the state constitution, but so be it. The office that Spear works for is directly tasked with protecting the people of Colorado from infringement on constitutional limitations by those selected to uphold law in the state. Spear used his position with the state to direct an incompetent magistrate into denying plaintiff his birthright of the court of record. So that was that. And then this is just basically restating that in the trespass in the case. Defendants having conspired to deprive plaintiff of his birthright of a court of record. Okay, so defendants have acted beyond the limitations of their authority with the court system to deny plaintiff his unalienable right. Defendants have acted against oath and ward with the federal constitution. Defendants have denied plaintiff due process of law as they have banned him from his court beyond the limitations of the federal constitution, and he cannot answer to the issues occurring. For these aforesaid reasons, the inferior court lacks jurisdiction and must grant relief found in demand for relief and judgment. So count 2, trespass in the case. This is what I was saying was basically restated. Defendant Jackson has intruded on the proceedings of the plaintiff's court. That's a summary statement. That should actually be altered, but anyway. Corey Jackson acted in excess of the jurisdiction authority in his role as magistrate to manipulate the proceedings. Again, that's another conclusatory statement. I would have written it like that. This must have been Drew's part. Corey Jackson, after being lawfully disqualified from all cases, still intruded on the cases with no authority. Again, that's conclusatory. Jackson used his position with the court system to intrude upon plaintiff's cases and deny plaintiff his rights as protected by the federal constitution and Colorado statute. Again, conclusory. Corey Jackson, in violating law, statute, and Colorado Code of Judicial Conduct, lacked capacity as a judge and a magistrate, and therefore as a man deprived plaintiff of his rights. That was a point that he wanted to make because we're saying, look, he can't act as a judge if he's acting outside his authorities of a judge. So he's just a man. Defendant Nibbitz, in utilizing her position with the court system by refusing to file plaintiff's returns and motions, which is an act outside of limitations of the federal constitution, trespass on the case by denying plaintiff due process and the ability to file in his own courts. And again, when you're filing a state action, you should probably stick more to state constitutions than federal. This is probably something that Drew wrote. I might have fixed this later, but I would put in that it's a violation or outside the limitations of the state of the Constitution for the state of Colorado is what I would say. So count 1, trespass with specifics. This is getting into like going back and forth with understanding of some of the law that was stated in here. I think I'll just skip over this because, again, you guys can read this on your own. This is where he kind of puts the law and the facts together. Common law and constitutional principles of government or sovereign immunity have never permitted government agents to commit trespasses in violation of property rights, which is, of course, point here. I mean, Drew's case was his own property. His child was also his own property. We put in various different parts of law in here that's important. I put in bold. Equity will not intervene where one is a plain adequate remedy at law, which was the point of which they were trespassing upon because Drew was just trying to get his case done, filed, over. The original complaint filed in an action fixes the nature of the suit, by what arm of the court it should be tried, and whether either party is entitled to a jury. So when he filed the suit, it was at law, not equity. And of course, there's more law here that you guys can use for when you file your counterclaim. Pledge. The plaintiff in common pledges to prosecute the defendant at law in this court of record until all matters and actions are concluded to judgment as the common law requires. Yeah, the word conclusion, I think it was probably supposed to be here, would be my guess, because that's where the conclusion probably should have taken place. I have a terrible habit of correcting things even if it doesn't matter anymore. So you do the pledge, so you pledge to prosecute, and then demand for relief and judgment. So for the above stated causes of action, therefore, plaintiff brings the suit. For the above stated claims, plaintiff requires the following relief. Wherefore, plaintiff requires relief and judgment against the defendants as follows, and wherefore, plaintiff seeks judgment against defendants as follows. On all claims and causes of action, plaintiff wishes for the declaratory judgment against defendants for actual damages, punitive damages, the cost of this action, and all other just and proper relief that the court sees fit to grant and order. Now again, if you're the sovereign, then it's your court. That under the law of this case and the authority of this court of record, the court enter a judgment that the defendants have acted arbitrarily and without care. I should say have abused, not his, but their, it should be their delegated authority. But anyway, their delegated authority and it has acted not in accordance with law, but under the color of law and in excess of their vested constitutional jurisdiction, not its, because we're talking about the defendants here. But anyway, so you go through what you want. So this was what Drew said as far as he wanted against these idiots, close to $1 million for basically stealing his son. I would say that's legitimate. So that was this case, and for injuries from the stupid clerk, that was $250,000, and injuries from the other idiot were $50,000. And then you just say, yep, that the court grant plaintiff other such further relief the court sees fit and just, so on and so forth. And notice of default, and so this is where you get into the nil dissent, or nil decant. Default judgment against the defendant. Notice of default, defendants have, that should say, this should match that, obviously. So again, another typo. 21 days from service process to answer plaintiff. In all actions stated herein, or the court will rule in favor of plaintiff and award plaintiff all damages stated and relief required above by nil dissent, default judgment against the defendant. Again, this means he says nothing. Verification, this is where it's verified to say that everything that you said above is true and correct. On such and such date, House of Nelson, one of the people of Colorado, state dignitary, counter plaintiff, and again, test day, and that's it. That's the totality of a case at law. Now, this case is what got filed. As he mentioned in this case, they didn't answer. They had to, they just kept moving forward. This now gets into the binding arbitration process. Okay, so what happened? So he filed all that, filed those cases, defaulted them. Then he went and filed for binding arbitration. And again, I can't remember the name of the company. I was actually going to look up and pull his file and actually give you guys basically the order form, the request form for the company to have an arbitration hearing before them. I don't know if that company is still in business. I think they are, but it was kind of like a smaller arbitration company, which we kind of liked because I talked to the CEO prior to doing this, being like, look, this is what I have as far as this contract is concerned. Would you guys have any problem basically adjudicating this and doing binding arbitration proceedings? After like an hour and a half conversation with her back and forth, she's like, well, no, I don't see any problem with it. And so all you can do, and she said, it's not up to me anyway. She said, it's all up to the arbitrator. So it's whatever the arbitrator decides. And then, that's what she's like, that's what you're stuck with, right? I'm like, yeah, no, I get it. Each arbitrator, they are their own authority. And the reason is because just like we saw in the history of Roman civil law, the arbitrators predate the Roman civil law magistrates. And when you have a contract, a lawful contract that two parties have entered into that says that this is exactly how you will take care of this situation if any problem arises between the two of you, that it will be through binding arbitration. Well, then guess what? You don't have a choice because you're the one that entered into the contract. So if you've entered into the contract, there isn't much you have to say about it after that. You're kind of stuck. We knew this, obviously, because I wrote it. And I said, okay, Drew, then if the court of record thing didn't stop them, let's just put it into binding arbitration. Let's, throw it to somebody else's hands and, let them take care of it, basically. What he did was what he gave to the arbitration company, when you file for arbitration, right, to a company, what you do is you make sure that you've processed, served the status doc set on whoever it is you're going after. And this had completely happened in this scenario. With the exception, I think, of maybe the clerk. But it doesn't matter because the clerk, having been put on notice of the KW, you don't have to process serve the KW for it to be of binding effect, but I certainly wouldn't suggest to anyone not to serve it, because what it does say in the KW is that if the appointed trustee has notice of, and notice doesn't necessarily mean full process service, but again, this is your life and your estate, so I wouldn't cut corners. You really do want to process serve everybody that you have to, that you want to make sure to put under the bus, because what you're going to want to do is get that process service affidavit, and then what you're going to do is you're going to send it into the arbitration company of proof that they did get served. To hire a process server is about $75 to $100 for each person on their side that gets served. Now that doesn't mean that the process server goes and like gives to 7 different people if they can't get through the front door of an office building. You know, says to them, "Oh, take this to so and so. Oh, can you take this to so and so?" That's not what happens. What a process server has the right to do, because they're literally an officer of the court, is to directly demand access to someone at their workplace. And I've seen this happen before too. And I've also heard of some other interesting times with other occurrences happen. I had appointed someone as a special master of my superior court, and he was doing process service. I needed him to go do service on the clerk of the court. And so when he went there, he went up to the front desk and did exactly what I told him to do. He went up to the front desk and he said, "You know, so and so is the clerk of the court here, so and so." And she said, "Yeah." She's in the back. "Do you want me to go get him?" I said, "Yeah." It's okay. So he steps back from the counter and he kind of turns to his side and he realizes that there's a federal marshal standing there, who he didn't really see as he walked in. He just kind of walked right past him because he was kind of in the corner. But he was holding some documents, you know, like a folder and a few other things. And he just casually starts shooting the shit with him. He says, "Oh, it looks like you're, you know, you serving people too today? You're on process duty today," or something like that. And Marshall says, "Yeah." Says, "Yeah, it's fun stuff. I'm just doing it for a friend." And he's like, "Yep, I know what it's like." And so then by this time, the clerk's starting to walk forward. He steps up to him and he says, "Are you Thomas?" I think his name was Thomas Klein, I think. Anyway, he steps up and says, "Are you Thomas Klein?" And the clerk's like, "Yeah." And the clerk's a little spooked because he sees the federal marshal behind him, which he wasn't exactly sure why he was there either. He says to him, "I have service for you," and he hands out the documents that I told him to serve him. And the clerk takes a couple steps back and he's like, "Well, I don't want to take those." And so then my friend goofingly turns around and says to the marshal, "Look, he's trying to evade service." So the federal marshal steps forward, grabs the paperwork out of my friend's hands, takes 2 more quick steps towards the clerk, which freaked him out. And then he shoves the paperwork into his chest and lets it go. And he says, "You've been served," like right in his face. My friend, my special master, just started busting up laughing, and he just ran out of there because he's like, I couldn't stop cracking up. And since he did just get served, even though technically it was by the federal marshal in a weird way, by proxy kind of. I mean, technically he'd been served the second that he walked in, told him that he had service. It was just a funny story because it taught my special master that, yeah, that's just what you do. You just shove it in their face and drop it. They've been served. That's it. That's all you gotta do. And then what you do is if you're the process server, or what they do, if they're process serving for you, what they'll do is they'll write out what's called a process service affidavit. Oh yeah, thanks, Dick. That's right. The name of the arbitration company was Sitcom Arbitration. That's right. I've got a redacted template for anybody. Then I put it into the notes. It's handout number 9. So it's a redacted process server affidavit that any of you guys can use. And here's the thing. Anybody over the age of 18 can process serve documents on anyone else, even a judge. And if you have someone do it, make sure that they use the template that I gave in here for you guys. So I'll just open up that real quick and show what this looks like. Stuff in red is what you need to change as far as personal information is concerned. So your court case number, whatever, and actually that should be in red too. Affidavit of service, in re, whatever it was that you served. In re means in regards to. So in regards to whatever it was you served. So status doc, public record number, blah, 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 whatever it was. If it's a plaintiff defendant thing, then this whole court thing is, if it's not a plaintiff and defendant thing and you just want them a process service affidavit for someone serving your doc set, then just wipe out this whole top section. Just wipe out the whole heading section for the court. You don't need it. It can just literally start with process service affidavit at the top. Comes now John Adam Doe and states that I am not a party to the whatever it was you served for John Henry House of Simon, who would be the guy that you served it for. That I am over 18 years of age, that I am one of the people of whatever, and that I have served one, and then it is one file stamp copy of whatever you served or whatever it was, to whoever they served it on, and then the name of position and office, if there was one. So, like Gary Johnson, clerk of the court of Ashe County or something, whatever. Or Gary Johnson, sheriff of Ashe County, something like that. And then the date on September, whatever, 2000, obviously 20, by leaving, or 21 now, by leaving said copy. And then this is where you state how you did it. By leaving said copy at the front desk of the office of Gary Johnson with the secretary or whoever was there at the said desk, who, at the time of service of the aforementioned documents, was an employee of Winnebago County, or whatever it was, and apparently in charge of the office of Gary Johnson. Now, that last part right there is extremely important, because if you get some guy or gal with some uppity sense of presumed authority and tries to cock block you about, oh, you can't go in there. Yeah, you can't serve him. He's busy right now. You can't go do that. Okay, fine. You're apparently in charge of the office. So you drop him on the desk and you walk out. You say, Gary Johnson's been served. That's your problem. And you walk out. Because if they're stopping you from getting to Gary Johnson, they're apparently in charge of the office. And that's all you got to put down, that they were apparently in charge of the office that day. And that's all you got to do. And then so the aforementioned served document is on file with the clerk of the court, case number whatever. Or you could say the aforementioned served document is on file with the county recorder's office, public record number, blah, blah, blah. And then date served, time it was, who got served, was it male or female, service address, plaintiff claimant, if this is applicable, or it would be petitioner respondent, if it dealt with binding arbitration, and then defendant, whatever. And then, again, a test day, it's pretty much exactly the same way as the other one is. Served by whatever, signed, declared by me, and this is a place for a notary public, because you process service affidavits are one of these types of things. It's perfectly okay to go and get signed by a notary. Just go down to your local bank and tell them I need a notary. I need some stuff notarized. And they'll say, sure. And you have this all filled out, and you just sign your name here, and then the notary will sign and stamp and put their little thingy over here, and that'll be the end of it. And then you can file that into the court, and you can also file that with you need to file it with your binding arbitration proceedings. So that's process service affidavit, and that then is proof that whoever the hell it was that's coming up against you, and in this case, in Drew's story, it was the judge, the clerk of the court, and then whoever the hell that skip guy was. I'm not sure if it was a cop or if it was the sheriff. Or again, it might even have been a district attorney. But again, that would be something that I would make absolutely sure of to put into the court case, even though technically he was stating for each one of those people that they were not acting in their official capacity, but that they were acting just as men and women outside their official capacity because they exceeded their jurisdiction.